the former president was indicted in Manhattan on charges stemming from his falsification of business records, covering up payments that were made to Stormy Daniels. This is completely separate conduct. This is more recent, all post-presidency conduct, what was just indicted in Florida. And it relates to his decision to take and then keep and then share some of the most classified, top secret documents that were in his possession as president, relate to national security, nuclear capabilities of other countries, Department of Defense information. So that is a crime. And then on top of that, once he learned that the federal government, specifically Special Prosecutor Jack Smith, was investigating his retention of those documents, his decision to try and convince his staff to hide or destroy those documents, to falsely represent that they had given over all the documents when they had retained a significant number of those classified documents, and to obstruct justice. And that's different from the Fulton County investigation, which is looking into his efforts between the election, the November 2020 election, and then the months following that to basically to interfere with the election in Georgia and to his call to Secretary of State Brad Raffensperger and other copies, and other conduct, allegedly falsely claiming that that he had won the election and that it had been stolen. Say that any indictment in which you're facing a potential term of prison, it doesn't matter if it's state or federal. The main difference, after you get past conviction, the main difference between federal and state is that there's no parole in the federal system. So if he is sentenced, and some of the charges, the indictment was unsealed, I think within the last hour, and I've skimmed over it. Some of those charges carry, potential 20 years in prison. And so if he is sentenced to 20 years, he's going to serve 20 years. In the state system, obviously you can apply for parole, but that doesn't exist. That was abolished over 2 decades ago in the federal system. The thing to me that highlights exactly how serious they take this, like I mentioned before, they had some charging decisions they could have made, a lot of different statutes. So one of the charges they could have brought is 18 United States Code 1924, which is the retention of classified documents. And that's any classified document. And it carries a potential sentence of up to 5 years per violation. They didn't choose that statute. They instead chose a different statute that relates solely to national security documents, and it carries a potential 10-year sentence. And what that tells me is they see a material difference in retaining classified documents, which could be about anything. Documents can be classified for all kinds of reasons, but he retained top secret classified documents. And those are documents that directly relate to national security. And so they chose that particular charge for a reason. They're trying to draw that line between the retention of classified documents and top secret security related documents. And another thing that's different, or at least the way the indictment reads on first pass, is that simply having documents in your possession, if you're not aware that you have them, or if you didn't take them knowingly and willfully with the intent to retain them, that may not be criminal. If you look at the indictment, and it is 49 pages long, it is detailed. It's what we call a speaking indictment. They have gone into exhaustive detail to explain exactly what their evidence shows and detail out verbatim quotes from things that he has said, from things that he told his attorneys allegedly. And I think the reason why they did that is because they knew that with this indictment, they needed to make their case early. So that indictment reads as their evidence. You can read it and know exactly what they found, exactly where they see this case going. And I do think people should read it because it's fascinating. I knew that it was going to cover some of that conduct related to national security documents, but it's pretty damning. And that was not an accident, them choosing that particular statute. So what's going to happen on Tuesday? It's called an arraignment. And that happens in every criminal case. The defendant comes to court they are officially presented with the charges against them, and he will enter an initial plea, probably not guilty. That's what most people do. I think we can certainly expect that in this case. And then the judge may hold a bond hearing there. I doubt the government's moving for detention. I doubt they're going to try and keep him in jail while we're waiting for this trial to happen. And the reason why I think he's going to remain on bond is he's being allowed to show up on his own. He was issued a summons. And that is basically something that the court signs. This one was signed by Judge Eileen Cannon, telling him to come to court on Tuesday. Most often what happens is that when someone's been indicted, an arrest warrant is signed by a judge and they are arrested and brought to court. So the fact that the government allowed him to show up on a summons rather than being arrested and brought to court tells me that they don't consider him a flight risk or a threat, and that they're probably going to support him remaining on bond. So this is just going to start the process. And then the government will hand over all its evidence to the defense. We'll probably see a bunch of motions back and forth. There'll probably be a motion to dismiss the indictment. There's going to be a lot of litigation, and then presumably ultimately a trial. And only after the trial and after he's sentenced will he have the opportunity to appeal. And so that's a long way off. We're going to be looking at this for a long time. It could be, it is not unusual for a federal case to take a year or more, and that's in simple cases. So in a case like this, where we can anticipate a lot of litigation before trial, the lawyers are going to do everything they can to try and delay trial, to try and get the judge to throw out the indictment. Probably going to see what we call suppression motions to suppress the evidence that was seized from Mar-a-Lago. They'll probably file motions claiming executive privilege. We know they've already tried to litigate that issue. They have not really litigated it in full. It was litigated, you may recall, about a year ago when the subpoena was first issued. And same judge, Eileen Cannon down there, appointed a special master to oversee the collection of documents, because Trump's lawyers were saying, look, these documents, it's executive privilege. We don't have to hand these over. And so she appointed a special master to review those documents and determine if they were subject to privilege or not. The 11th Circuit, which is the appeals court that oversees Florida, Alabama, and Georgia, reversed her on that and said that they have to hand over all those documents. But I don't think we've seen the last of the executive privilege defense. I think he will raise it again. And so all of those things are just going to delay this process. And so I don't see a world in which this trial happens within the next year. It could, but given how much litigation I anticipate, I would say it's, we're probably looking deep into 2024, maybe 2025 before we even have a trial.